Hi, Tony DeWitt here, Missouri appellate attorney and a guy who tries to answer questions here on YouTube. Today somebody writes, what is a power of attorney and why would I need one? The answer to that question in just a second. A power of attorney is a document that is executed by someone that the law calls a principal. And the purpose of that document is to appoint what the law calls an agent. That is, someone to act on your behalf. Now, the law of principal and agent is pretty clear in this country. And as a result, there are some things that everybody needs to know about powers of attorney that may not necessarily be obvious up front. The first of these is that a power of attorney gives you the authority to act as an attorney in fact. That is different from acting as an attorney at law. As an attorney in fact, you have the ability to do for the principal anything that the power of attorney gives you the authority to do. Now that brings us to the next issue in powers of attorney, which is whether they are general or specific. A general power of attorney gives you the power to do each and everything that an individual could do on their own. For example, title a car, buy a house, sell a house, put money in the bank, take money out of the bank. Any of those things are things that can be conveyed in a power of attorney that is general. A specific power of attorney is substantially different from that. It is limited specifically to one act or series of acts. For example, you see this quite often in the car dealerships. They will get a power of attorney to act as your agent to title and register your car as a convenience to you. But in order to do that, you have to give them this power of attorney. And it strictly limits them to do only that which is necessary to register your vehicle. So that's the difference between a general and a specific or limited power of attorney. Then there is one additional kind, and that is called the durable power of attorney. At common law, when someone became incapacitated, for example, they went into a coma, or they suffered from dementia, they were considered to be unable to make an informed decision about an individual's ability to transact business on their behalf. So, for example, if you have somebody who is perhaps suffering from dementia and they have a power of attorney that gives their cousin or their uncle or their brother the power to take money out of the bank, that would, under common law, be revoked the minute that the doctor certified that she was not of sound mind, because she can no longer consent or object to anything that the agent does. The law has created a way around that through what is called the durable power of attorney. A durable power of attorney survives the individual's incapacity. So somebody who suffers from dementia can be represented through a durable power of attorney. Somebody who's in a coma can be represented through a durable power of attorney. And then finally, there is a new thing, relatively new, probably in the last 20 years, called the durable power of attorney for healthcare. The durable power of attorney for healthcare gives someone the right to make your medical decisions for you as if you were right there, as if it was you making those decisions. This is an awesome power because it literally is the power of life and death. So, for example, if you want to have full heroics, that needs to be spelled out. Full heroics in this context means CPR, drugs, defibrillation, all the things that happen to somebody when their heart stops. If you want all of those things done, then that needs to be spelled out in the durable power of attorney. And the durable power of attorney will survive your incapacity. However, it will not survive your death. Once somebody dies, then estate law takes over, and the only person that can act for the benefit of the decedent's estate is the person who gets appointed by the court. Now, all of this is important for a number of reasons. And here are some of the things that people often don't think about when they're thinking about durable powers of attorney or powers of attorney generally. An agent has no more power than the principal gives him. And an agent cannot do something that the principal does not allow. So, for example, if you have a power of attorney to act on behalf of your aunt who is in a nursing home, and you decide that you want to move her from nursing home A to nursing home B, then you have to, if she does not agree to that, you can't do that over her objection, because a durable power of attorney, it is secondary, and a power of attorney generally is secondary to the wishes of the principal. So as long as somebody is competent and cognizant of what's going on, if they are the principal, they have the right to overrule their power of attorney, not the other way around. The other thing is this thing called a breach of fiduciary duty. This has been called, among other things, by Supreme Court justices, the duty of an honor most sensitive, which means that you have to act strictly on behalf of the principal, the person who has appointed you. You can't engage in self-dealing. So if Aunt Ethel wants you to sell her car and she gives you a power of attorney to sell the car, you can't then turn around and buy the car from yourself as the power of attorney, because that's considered to be self-dealing. The only way you can do that is if you get permission from your principal in order to do that, in which case it's not a power of attorney issue, it's a direct permission from the person who owns the vehicle. Self-dealing is a real problem. Taking actions that are inconsistent with a person's best interests in a power of attorney situation is also considered to be a breach of fiduciary duty. The reason that's important, you can be sued if you breach your fiduciary duty. And you may not wind up being sued by the individual, the principal. You might wind up being sued by the administrator of the estate after the death of the principal. That happens quite often in these situations. We often find, particularly as we investigate in estate situations, that somebody with a power of attorney has taken money from the estate, from the principal, and used it for their own purposes. And it is the administrator's job in that situation to get that money back. And that happens with some frequency. So I hope I have made the idea of powers of attorney, and particularly durable powers of attorney, somewhat interesting and informative. If you believe that you have someone who is going to represent your best interests and who you trust, it is a good idea to have a durable power of attorney for healthcare, because there may come a time when you can't make a decision for yourself and you need someone to make that decision for you. In my case, I have appointed my wife, and my wife has appointed me, so that in the event that either one of us is incapacitated, we have someone that we trust to make our medical decisions for us. You can often find these forms as fill-in-the-blank forms from your local state bar association. Thank you for watching. I hope that you found this interesting and helpful. I wish that you would press the like button and also click on the subscribe icon and the notification bell so that you can be notified whenever I release a video on this channel. Thank you for watching and have a great day.